Hello and welcome to our event which we're hosting with Hayes Education today. My name's Jenny Arrowsmith. I'm a partner in the employment team and I'm joined by my colleague Siobhan Mulrey, who's a senior associate in our employment team. We're employment specialists, but together we look after all the school clients that we work for, many of which I know are on this chat today, and it's nice to see some new people as well. So we've got a session which we're planning will last up to 1 hour. What we're talking about today is protecting your trust. At this time of year, or certainly in the spring term, often what we end up advising schools on is your restructures. You're looking ahead to the next academic year, you're thinking of the kind of things that you need to put in place, so you've got the structures to deliver what you need to deliver and do so in the most cost efficient way. And obviously you've all got budgetary constraints as well, which I know is a concern for everybody, so you're constantly needing to look at what cost efficiencies you can put in while still retaining a staff and recruiting staff and being an attractive employer. We understand all of that, and one thing that emerges quite often is that contracts of employment typically in schools are not necessarily as up to date or as fit for purpose as they can be. And for the reasons we'll go on to explain, there's a number of areas where I think there are opportunities for you as an academy trust to rethink your contracts of employment without compromising your ability to recruit or retain staff, but definitely to make some cost savings and to give you the flexibility I think you probably need as you are making plans for how to manage your budgets and implement any changes you need. There's quite a lot in there, and what we're hoping to do in this session is just touch on the surface. So I'll just move to the next slide, which shows the sorry, the slides are not moving forward. So we're going to cover some of these areas, and Siobhan's going to do some specific legal updates which very much need to be looked at now. In doing that, what we're doing with a lot of clients is we are also looking at some other arrangements and seeing what additional benefits you can do in terms of your templates, and we'll explain all of this as we go through as well. There is a facility for submitting questions, so please do submit your questions. We will do our very best, time permitting, to get through all of those questions. And if we don't have time, if you put your name, we'll get back to you as well as in follow-up to this event. So please do use that facility. So what are you trying to do as senior leadership? You're obviously trying to deliver outstanding education. You're trying to grow your trust. You're trying to maximise the efficiencies that come with being an academy trust. You're needing to reduce cost. And really, a lot of this is about challenging the status quo. As we come on to, there's a lot of things that you've inherited through being through TUPE terms and conditions, but also through custom and practice of the way things have always been done in the sector. And what I'd like to challenge you today is just to think, well, what do we need going forward? What flexibilities do we have, and how do we go about doing that? So, like I say, we're going to touch on some of those areas. Initially, what I'm going to do is just hand over to Siobhan, who's going to talk to you about some Section 1 updates, legal updates. Sorry, the slides are moving quite slowly, so bear with me. There we are. So Siobhan, I'll just hand over to you at this point.
Okay, morning. Thank you, Jenny. So first of all, I'm just going to run through some of the new legislative requirements which have come into force this year. So first of all, many of you will be familiar with Section 1 of the Employment Rights Act, which sets out requirements for what needs to be included within a contract of employment, or sometimes known as a Section 1 statement. So that the Employment Rights Act has been in force since 1996. So this isn't a new requirement, although it has been updated this year. So previously, this requirement only applied to employees, and the statement needed to be provided within the first 2 months of the start date of employment. The update to that this year is that for anyone engaged on or after the 6th of April 2020, they must receive the new statement as a day one right So it needs to be provided on the first day of employment or before that point. Other changes which have come in with that requirement is that it applies to employees as well as workers. So that will include some of your casual or your 0 hours workers. And the information which needs to be contained within the contract has changed, and quite a lot of information does need to go in there. So there are requirements in relation to rates of pay, hours, how pay is calculated and how often it's paid. It also must include days and hours of work, and if those days or hours of work vary, how it would vary and how the employee is told as to what their hours will be. The contract also needs to contain some information in relation to the right to paid leave, so that's in relation to holiday or sick pay, and how that is calculated. Now, this isn't a new requirement in relation to holiday and sick pay, but we do see in a lot of school contracts that they don't contain enough detail in that regard, and therefore they aren't compliant with Section 1. There's also further information which needs to be included in relation to probationary periods, any benefits that person might be entitled to. So that would include contractual or non-contractual benefits. The contract should set out what is contractual and what is discretionary. There's also information in relation to training which needs to be provided and whether or not that is compulsory. And also in relation to training costs, so thinking about your rights to recover any training costs if that individual leaves employment within a period of time after receiving training. And also details in relation to other types of leave needs to be included, so that would be the likes of family related leave, you know, maternity, paternity, but also looking at perhaps if you have a leave of absence policy. Now, some of this information can be contained within a separate document, for example, within a staff handbook or a separate policy, but a lot of the information needs to be within the contract itself. So, for example, simple references to the Burgundy book or the school teacher's pay and conditions document in relation to hours of work, for example, wouldn't be sufficient, so that needs to be within the contract itself. And I've set out on the slide there some of the consequences of non-compliance with Section 1. So an employee or a worker indeed can bring a claim to a tribunal and ask the tribunal to determine what their terms of employment are. And if they're successful in showing that they haven't been provided with a compliant Section 1 statement, then they can be awarded 2 to 4 weeks pay, capped pay. So moving on to some of the rights of existing employees or workers. Now, as I've said on the previous slide, the changes apply to anyone who's engaged on or after the 6th of April 2020. So you don't necessarily have to make immediate changes to contracts for your existing staff unless they ask for an updated statement. So if they do ask for an updated statement, then you'd have 1 month to respond. Or it would also apply if you are deciding to make changes to any employee's terms and conditions. So perhaps if they're moving into a new role, or if there are any other changes to their terms, a new statement needs to be provided which is compliant with the regulatory requirements. For these purposes, it's not necessarily about providing new terms of employment, it's ensuring that your templates have the right information in there. And it's also worth bearing in mind that a claim in this regard can't be brought as a standalone claim. It would need to be brought alongside another claim. So, for example, perhaps an unfair dismissal claim, and then this would be tagged onto it. Now, obviously, it's not necessarily the compensation that an employee might receive isn't necessarily that significant at 2 to 4 weeks pay. However, we have dealt with one case recently where we've got a multi-party holiday pay claim with 150 claimants. Now, the holiday pay element isn't worth an awful lot, so the maximum any of those claimants is entitled to is about £500, and a lot of the individuals are entitled to much less than that. But the failure to comply with Section 1 requirement that's been tagged on is worth a lot more and has become a lot more costly. So you can see where there is multi-party claims, where that would be quite an expensive claim. Now, I mentioned that the requirement applies to employees and workers, so I'm just going to touch on briefly what we mean by the different employment status of individuals. So in employment law, we recognise 3 different types of employment status: employee, worker or self-employed. Now, confusingly, in tax law, there's only 2 recognised, which is employee or self-employed, but I won't get on to, I won't go into detail in relation to that. Now, when we are looking at the status of an individual, you've got your employee who's entitled to the full range of employment rights. So they're deemed to have continuous employment, they have unfair dismissal rights, they're entitled to holiday pay, sick pay, etc. And then at the other end of the spectrum, you've got someone who is truly self-employed, so they're in business on their own account. They are able to work as and when they choose and where they choose. They might often work for different organisations, generally invoice for their time, more of a consultant type arrangement. Now, you've got in the middle a bit of a halfway house, which is the status of your worker, who doesn't quite benefit from all the rights of an employee, so wouldn't benefit from unfair dismissal rights or continuous employment. But they are entitled to some of the rights that an employee is entitled to, so significantly in relation to holiday pay, statutory sick pay, for example. Now, you might have some individuals, casual perhaps, or 0 hours workers. Now, those casual workers, I'm saying worker, but they could actually be deemed an employee. So you might have a 0 hours employee who still benefits from continuous employment, still has the right to bring an unfair dismissal claim, whereas you might have a 0 hours worker. Now, the key really when looking at those individuals is, well, first of all, when a tribunal would look to determine what someone's employment status is, you'd look at the contractual documentation in the first place. So this is where it's really key to ensure that your contracts do reflect what the intention is for the relationship between the 2 parties. Now, that will be the starting point, and that will be what that person is deemed to be. If the contract says they're a worker, then that's fine. However, a tribunal will look behind the wording of the agreement if it doesn't reflect the reality of the situation. So this is where companies like, for example, Uber and Deliveroo, etc., have got into a bit of trouble because they've labelled an awful lot of people as self-employed, whereas actually the reality of the situation is that they are under quite a lot of control by the organisation. So it's tripped them over into being regarded a worker rather than self-employed. Now, this will be particularly key in the school sector when you're looking at perhaps invigilators or peripatetic workers. So it's ensuring that you've got that clear documentation in place and that you are working with that individual in accordance with what the document says. Another area which emphasises really the importance of ensuring that your contracts are well drafted came up particularly in this case, a Supreme Court case with Miss Hayward. So I'll run through the facts of this case briefly. So this is a case that actually Irwin Mitchell were acting for the claimant in this case against Newcastle NHS Trust. The claimant worked for the NHS for over 30 years. On the 13th of April 2011, she was informed that she might be made redundant because of the merger of 2 NHS trusts. Now, her terms of employment confirmed that if she was made redundant before her 50th birthday, she wasn't entitled to an early retirement pension worth £400,000. Now, the crucial date for the purposes of this case was the 27th of April 2011. So if she was given notice on or after that date, then she would have been entitled to this £400,000. Now, clearly the employer in this situation wanted to avoid that being the case. She was actually on holiday, pre-booked holiday, between the 18th and the 27th of April. The trust issued notice to her on the 20th of April, and that was sent to her by recorded delivery to her home, and it was also sent by email to her husband's email address. Now, because she was obviously away at the time, she didn't open and read that letter of notice until she returned from holiday, which was the 27th of April. Now, the trust argued that the effective notice date was the date of delivery, which was when it was actually delivered to the house, which was the 26th of April. She argued that it wasn't effective until she'd read the notice on the 27th. Now, obviously, this one day makes a £400,000 difference. Now, we went through the tribunals and the courts, and ultimately, the Supreme Court held that there is an implied term in all contracts of employment that notice can only run from the date the employee receives notice and has reasonable opportunity to consider it. Now, so she won her case, which was great news for her and for Irwin Mitchell. And really the learning point in this case for employers is that had her contract of employment included a provision which expressly stated when notice would be given, so for example, if it had said notice will deem to have been received 48 hours after it had been posted, then that would have trumped this implied term, and none of this would have been a problem, and notice would have been effectively served when the trust wanted it to be served. Now, this is particularly key when we're looking at deadlines for when notice needs to be given, in teacher contracts, for example. So it is important to ensure that notice is served and that the employee has been able to read it. So maybe it's looking at delivering it by hand, or ensuring that your contracts reflect that wording which states when it will be deemed to be served. Because there are certain points in the year, as you'll know, if we miss those dates, then that individual will be entitled to a lot more notice. Moving on, I'm just going to have a little look at some holiday pay cases which particularly impact on the education sector. So first of all, well, there's been a change in legislation which is changing the reference period for holiday pay calculations. Now, all workers are entitled to at least 5.6 weeks leave under the working time regulations, and they must receive their normal pay for any annual leave taken. Now, if you have any workers whose pay varies because they don't have normal working hours or their days of work vary, you have to calculate what their holiday pay is. It used to be by looking back 12 weeks to work out what their average weekly rate of pay is and then paying holiday pay at that rate. But that changed on the 6th of April this year. So the calculation period has been extended to the previous 52 weeks. So this is designed to even out the variation in pay that casual workers might have. So it's just something to ensure that your payroll is aware of this, and it will apply to casual workers such as invigilators. And then another point on holiday, some difficult issues around when holiday is taken. So first of all, you might think it was straightforward that when an individual has taken their holiday, but often in the education sector it's not actually that straightforward, because some parts of the year might just be deemed unpaid leave, for example with term time only workers, or it might be deemed paid leave in addition to holiday. So the first thing to do would really be to spell it out in a policy or contract. So most of the school contracts we've seen don't say this, but you would perhaps say that annual leave is assigned to the first school closures in the holiday year. Now, you can probably argue that paid leave is taken before any period of unpaid leave. And this can be particularly important when we look, I've mentioned on the slide there, this case involving, the Agnew case. Now, that was about the underpayment of holiday pay, and the claimant in that case was looking back a number of years to argue that they didn't receive their appropriate holiday pay. The employer in that case argued that any break of 3 months or more where holiday wasn't taken broke the chain in the series of deductions. And based on current English case law, that is correct. So if there is a break in the chain of deductions, then that person can't look back further than that point. This was a Northern Irish case which went to the Court of Appeal, and they held that that wasn't the appropriate way to interpret the legislation, and that that individual could look back further than that. So although it's a Northern Irish case, it's not binding in England at the moment, but it does indicate perhaps where we might be going with this. I've mentioned on the next bullet point there, workers who, if they start or leave partway through the holiday year and they have their pay equalised over the year, so again perhaps your term time only workers, you might need to adjust the pay they receive to reflect the actual time they've worked and the amount of holiday that they've taken or they've accrued. So the contract, in order to comply with Section 1, it needs to make it clear how holiday is calculated and when it is taken. That's even more useful now when we're looking at, for example, the coronavirus pandemic. So most holiday may have already been taken, but if it's not, it needs to be set out with when it has been taken. You can give individuals notice as to when they need to take leave, for example, during the school closure periods, but of course there will be a number of teachers in particular who will have to work during some of the school closure periods, and therefore might not be able to take all of their holiday. So it's about ensuring that that holiday is taken when possible. I mentioned a couple of times term time only employees. Now, there are some horribly complex consequences when using term time only contracts. Now, of course, they are commonly used within the education sector, but we are seeing an increase in some of the difficulties around using those kind of contracts when interpreted against existing legislation which isn't drafted in a way to suit these kind of arrangements, particularly when you're looking at holiday entitlement, sick pay entitlement, maternity pay. There's one case which you may have come across which was particularly key for the sector, which is the case of Brazil and the Harper Trust. So in that case, the trust calculated term time only employees' salary based on a full-time equivalent salary. So the term time only salary was based on 39 working weeks plus a pro rata equivalent of the full-time equivalent holiday. Now, the full-time equivalent only received 5.6 weeks leave in that case, so they only had the statutory entitlement. So then they just pro-rated that to reflect the fact that this term time only person wasn't working a full year and added that on. Now, that makes a difference obviously in terms of the salary that term time only person receives, because the salary they receive is based on their working weeks plus their holiday. Now, the Court of Appeal has held that it was unlawful to prorate that term time only workers statutory entitlement to leave, the working time regulations clearly state that an individual is entitled to 5.6 weeks leave. So the Court of Appeal said even if that person doesn't work a full year, they are entitled to this as a minimum. Now, you can prorate any additional leave on top of that. So quite often a full-time equivalent will be receiving more than statutory entitlement. So that additional part can be prorated for term time only, but you still need to ensure that that 5.6 weeks is given as a minimum. Now, the implication of this, not only for term time only workers, but anyone who works partway through the year, could be quite significant. So even if you have an employee who works 1 week in the year, based on this judgment, they'd be entitled to 5.6 times that as leave. So you'd work 1 week and get over 5.5 weeks annual leave in addition. Now that seems madness, but even the Court of Appeal highlighted that that is a consequence of the way the legislation is drafted. Now, earlier this week, we did discover that the Supreme Court has given permission for the Trust to appeal the decision. We don't yet know when that hearing will be, but on the basis that it is being appealed, many trusts are choosing to wait and see before making any changes to your term time only holiday. This is something the unions are alive to, though, of course. So this case was brought by Unison, and many of the unions are looking at this closely. What I would suggest you do is that even if you're not choosing to make any changes at the moment, it is worth looking at your workforce and calculating what the potential liability might be, and particularly taking advice if you are getting any movement from the unions or from the employees in relation to this, because you really need to think about the risk of the claims versus the cost of compliance. So that's about it in terms of some of the legal updates. I'm going to pass back to Jenny, who's going to look at getting the most out of your current arrangements.
Thank you, Siobhan. Okay, I'm actually Siobhan, state your meter. There's just a couple of questions I'm going to deal with really quickly that come through from that section. So we've had one question about examining vigilators who are employed on a casual basis. That's extremely common, and the question is just about how do we capture the right detail about holiday pay, time off and sickness pay, etc. The simple answer to that is I think you need a contract that reflects those arrangements in place, whether they're engaged as a worker or an employee, and this goes back to what Siobhan was talking about. And in fact, you need to have those statements now to reflect those arrangements as a result of Section 1 changes. So there are things that you can do, and we've got standard templates that we work with that can detail those arrangements, but the first thing is to understand whether they're employed or you engage them as a worker, which much will come down to the expectation on whether they need to accept the work if offered from you, etc. But if you needed any help with that, please do let us know. Another quick one, we had a question to ask whether the new contract should include a clause about furlough. I mean that takes us on into a whole different subject of furlough, but ultimately furlough is a very new concept, so it's very, very common that contracts don't have a clause which enables you to rely on that as deemed acceptance to be put on furlough. And it's not something I would hope is going to be regularly relied on. In other sectors, there's quite often a provision about layoff, which means that you've effectively got the ability to not provide people with work in a almost similar way to furlough, but without the benefits of pay. So the simple answer on that is I don't think it's necessary to include that clause. Hopefully we're in a unique time and it's not something we're going to see again, but certainly you do need to be asking for the agreement, so that's a slightly separate topic. So Siobhan's talked you through Section 1 status updates and a few legal cases that are very important in terms of getting your contracts as a basic up to date and legally compliant. So if you take anything from today, I'd be really encouraging you to look at your templates, look at your contracts and get them up to be legally compliant as a minimum. That then begs the question, well, what is the structure of our contracts? Because many of you will have a number of staff who you inherited through a TUPE transfer and are on local academy terms and conditions, and you may have also, as an academy trust, then taken on other trusts within other academies within to make a large multi-academy trust and have a number of variable terms and conditions. So I'm just going to try and give an outline of how that works, which is actually very complicated, but I think is essential for you to understand where you go from here and the extent to which, beyond those basic changes that we've just talked about, you might want to think about adding in new things. So as you'll know, when you do an academy conversion, that's a TUPE transfer, which has the effect of taking the service that has already been obtained in that previous employment, and it moves across. So if they've worked there for 10 years, that 10-year service moves across with you, as do their terms and conditions of employment. Now, bearing in mind that a lot of those people that TUPE transfer across would have been on local authority terms and conditions, they would be under Burgundy Book, Green Book and school teachers paying conditions, and those terms move across with you, to you, as do any trade union recognition agreements that were in place that apply, providing the bargaining unit stays identifiable. But given that unions typically would look after support and teachers, and you still have those structures of teachers and support staff, my view is that the recognition agreements that apply in relation to those groups would ordinarily move over, and so those arrangements would continue to apply. Now, so that means that you do still have these terms to deal with, but importantly, as an academy trust, you'll know also that there's the flexibility and the autonomy to set your own terms and conditions. And ultimately what that means is that for new staff that you appoint that aren't a TUPE transfer, you could put in place new contracts which don't have to incorporate the Green Book, the Burgundy Book or the school teachers terms and conditions. They may reflect parts of those just to bring it up to an industry expectation and help with recruitment and retention, but they don't need to incorporate the whole books. And there's a number of reasons which I'll go on to where I think it's important that you understand that difference, because if you simply refer to a document such as the Burgundy Book terms, everything within that Burgundy Book becomes a contractual term, and there's a number of particularly onerous areas really which are very cost prohibitive that you wouldn't necessarily need to take on. And I'll pick out some of those details, but that's really where we're seeing a recurring issue and additional cost for academies. So one of the things that a lot of academies are doing are looking at putting updating their templates and thinking, well, do we need to automatically incorporate these traditional terms and conditions, and to what extent are we happy to give that same level of sick pay but put it into our contract and make it work for us? And we're doing a lot of work around that, and what that does is it ultimately gives you a lot more flexibility. So I'll explain a bit about that, but because this is new contracts, you're not changing anything. You're not, you're offering a job to somebody who's coming in afresh, and they're accepting those terms and conditions. But what it does mean is then you will have a group of staff in your organisation who are on inherited TUPE terms and those that are on new terms, and that's quite common. And then often we will be asked the question, well, how do I harmonise those together, so to bring the new and existing terms together? And on that, I'd say that I mean it is possible, but within very limited circumstances, because TUPE is such that it does give an awful lot of protection to those terms being maintained post-transfer. But there are some opportunities, and I'll pick those out as I just go through this next section. So ultimately, I think where you need to be getting to with your contracts is, like Siobhan was talking about, legal compliance, and taking those case updates as well, and just making sure that your contracts give you that protection you need, the notice one being a really good one. And in fact, I've just been dealing with a situation where a member of staff didn't get the notice until 1st of June that they were going to be terminated, so that immediately, instead of their employment going to be ending on the 31st of August, they're now looking at termination date being towards the end of the year, and obviously that immediately means a lot more cost. So it is a real issue. The other thing that you're looking for in your contracts is you're making them you want to set out the benefits that you offer to your staff. And as an academy, This isn't just about taking away rights or anything like that. It's not that at all. It's about reflecting the benefits that you offer, and wording them in a way that makes it work for you as well. And some of the wording, bearing in mind the Burgundy book was written some 20 years ago, it isn't particularly clear. It is open to interpretation. You've got a real opportunity to set out perhaps a very similar arrangement or amended arrangement, but something that works for you, as well as putting additional benefits if you've got any. And like Siobhan said, you need to be doing that to an extent anyway to make them Section 1 compliant. It also needs to protect you. So there's a number of areas where we see recurring issues arising when terminating staff and giving them notice. And I'll mention a couple of points there. We've mentioned about status and clarifying the status of the workforce, but also flexibility is important too. So as a trust, you no longer really want your staff just employed to work at one school. There may be opportunities for them to work in other schools within the trust. In fact, you might actually require them to do that either temporarily or on a permanent basis. So how you define their place of work is really important, because if their place of work is just one particular school, and then you wanted them to work in another school within the same trust, the same employer, that is still technically a redundancy. And you require on their agreement to do that. Whereas if their place of work is phrased sufficiently broadly to be any place of work within the multi-academy trust, then you have the ability to require them to move subject to reasonableness. So that's just one simple example, but also flexibility in terms of this description of the duties. It enables you to have that flexibility of requirement as things change and as your needs change. I mentioned TLRs and secondments. I'll talk about safeguarding pay in a moment, but I've seen a few of these arrangements being put in place just almost as a bit of a goodwill, not properly reflected in terms of how they're documented, secondments in particular. I'd really encourage you just to think about how you do document them. So why are you giving the TLR, for what purpose, how long for? Thinking always what happens when we want to retract this, or if we're going to need to retract this, and what happens at the end of this comment period. So if you're doing those, again, it's important, I think, just to get those documented, because ultimately that will protect your trust in the longer term. So I said I was just going to talk a little bit about some of the things in these incorporated terms that we still see regularly as part of well-established multi-academy trusts, and challenge your thinking really just to think, well, do you need these as part of your terms and conditions? And if you were doing a refresh of your contracts, which our advice would be looking at the very least at those basic things that Siobhan's covered, the basic legal updates, do we want to start thinking about, for our new staff, having templates which don't automatically incorporate everything? Now, sick pay is an obvious one, because there's a number of areas here where when we're advising clients in relation to management of very problematic ill health cases, these come up. This one is particularly topical in terms of coronavirus. So you're all busy working, trying to get staff back to work and reopen the schools to as many year groups as possible, and you'll be doing that with some force now, given the latest announcements about returning to school full-time in September. The battle that a lot of our clients have had in the last few weeks, as I'm sure you have had, is that balance between those people who are saying that they are concerned about returning to the workplace and those who need to still be shielding, etc. Now, those that are under the guidance and need to shield, that's one, that's fairly straightforward in terms of the advice around the flexibilities you need to give to those. But those individuals who don't fall into those groups, who could in theory return to the workplace but are concerned, and that's where there's been a particular challenge in terms of how much can you require them to come back to work. Now, that again was the subject we were talking about on our last webinar, which hopefully you attended at the back end of May. But one of the things we flagged there, which has come out and been problematic, is a couple of terms in the Burgundy Book and Green Book. So Burgundy Book says that where an individual believes that they've been infected through the workplace to an infectious disease, and a medical practitioner supports that they shouldn't be attending, they're entitled to remain at home on full pay, and that full pay isn't deemed to be sick pay and hit with their triggers or to be taken from their sick pay entitlement. So that's one provision, albeit it's fairly limited because it needs this medical practitioner to say they shouldn't be attending, and it also needs some evidence that they've come into contamination in the workplace, which I'd argue is quite difficult in the current circumstances. But for Green Book, it's much wider. An individual just needs to say that they feel that they would be exposed to an infectious disease and that they feel it's unsafe to return to work. And in those circumstances, the Green Book provisions, drafted as they are, effectively give quite a lot of rights to an individual to say that they're not returning to work and to remain off on full pay. Now, if you hadn't automatically incorporated Burgundy Book or Green Book, those provisions wouldn't be there. That's not to say that you might not be still making flexible arrangements allowing some people to stay working at home and not requiring everybody back at work, but it gives you the choice, it gives you more options aligned with other employers. Another thing that you may well have come across, because we've definitely seen an increase in unions pushing this point, is in relation to this part that I've quoted in orange on the slides there. So in the Burgundy Book, under the sick pay provisions, obviously you've got your entitlement to your number of working days, full pay or half pay, depending on your sick pay service. But this provision says that in the event of an accident, injury or assault, which is supported by a medical practitioner, which could be occupational health, and if that arises out of the teacher's employment, then they would be entitled to an additional 6 months pay in addition to their normal sick pay. And what we've seen an increase of in the climate where work-related stress is particularly prevalent is the union saying, well, this individual is off sick with work-related stress, therefore any sick pay that they're receiving at this point should be full pay before their normal entitlement kicks in, which immediately is a huge additional cost. And it's very difficult to actually pinpoint what's work-related stress and what might be predominantly personal stress. And that is a recurring theme that we're having. Now, we've managed to push back quite a bit in terms of, well, how that provision came about and whether it actually is meant to cover such things as work-related stress, as opposed to, you know, your slips and trips and personal injury type claims. But there is this tribunal claim which, whilst not binding, did actually support that would be or could be in scope. Now, there's no binding case law on this. It's not well litigated, actually. But like I say, we've seen a bit of a trend of unions pushing with this point, so it's something to be aware of. Again, if you had taken the sick pay entitlements to the same number of working days provided in the Burgundy Book, reflected that in your own contract, but not incorporated the rest of the sick pay provisions, this wouldn't be part of those terms and conditions, yet your teachers would still benefit from what their reasonable expectation is of sick pay in the sector. So that's just something to be aware of as well. And then there's a few things around service, so whether you're expected for the purposes of the sick pay benefit to incorporate prior service. Now, if you've got people who've tutored in, then their service would follow with them for the purposes of benefits. But if you've got a new member of staff who's come from a different academy or a local authority maintained school, do you have to reflect the service that they've had with those for the purposes of sick pay, maternity, and such other service related benefits? The answer there is very much if you don't incorporate the terms and conditions in full, then no, you don't at all in relation to any of this, with the one exception of redundancy pay, which that's governed wholly by a separate piece of legislation. If it's Green Book, then yes, you do, and if it's Burgundy Book, then the wording isn't particularly clear, but my view is that no, you don't in relation to sickness. It only talks about incorporating the service of other local education authorities, so it really would depend on where they've just come from. But there's all sorts of technicalities in the wording around this point in the Burgundy Book, which talks about reflecting the amount of sickness they've had in the preceding year with another employer, and then how much they've had with you. And actually that to me just doesn't sound practicable, because I'm not sure that you get that amount of information from prior employees, and understandably so, because of data protection. And what that says to me is these provisions were very much drafted at a time and an age where you were under local authority employment, and there was a lot more freeway communication. So things have changed, and I think therefore these mechanisms and the extent to which there is any flexibility here actually doesn't work in practice. So there's a real opportunity just to clarify those arrangements and clarify the level of benefits. The other thing is your sick pay years are 1st of April to 31st of March, which is very fixed, and there's a few things around there that we'd be able to advise how you could maximise benefit in relation to the sick pay entitlement. And none of this is meant to suggest that we're saying about really reducing the amount of sick pay that you give to your staff. By all means, that is that is something you could do, but it might be something that you don't wish to do, and I'd understand that. It's just it's almost like the icing on the cake around it. How much do you need? Because at the moment they've got quite a lot of terms in there that I think you could narrow down with still keeping the core benefits that teachers would expect, as would unions. Notice periods is another one. Siobhan's mentioned about these timescales that you are working to in terms of giving notice so that it can end at certain points of the academic year, and there's a lot of practical reasons why that works both for our teachers and for yourselves. But the only exception to that really is in terms of gross misconduct, but there's been a number of cases where perhaps a member of staff has been given a number of series of warnings short of gross misconduct, but nevertheless warnings for misconduct, and then maybe they've got a final written warning and then they do something else, so you want to terminate their employment fairly and with notice. But if the timing of that is completely out of your hands, but you might, just because of where that sits, end up having to pay maybe even up to 6 months notice. Unless your notice provisions have a bit of built-in flexibility. So we've been working with a number of clients to build in that flexibility so that it works for you while still being a reasonable provision. Probationary periods is another thing to look at. You can have lesser notice periods within probationary periods, as well as do your contracts have a pile-on clause? That's a pay in lieu of notice clause. Because that would enable you to manage the date of termination much more easily, which in turn helps you then with recruitment for alternatives. And notice during sickness. So if you terminated somebody for ill health capability, the Burgundy book says that you need to pay them full pay for that period, whereas actually the basic entitlement in law would be that you pay them the normal pay that they would be entitled to during that period. So if they're on sick leave during that notice period, and they're only actually at that point entitled to half pay or even no pay, depending on the length of their sickness, then that would be what you pay. So again, there's another big enhancement under the Burgundy book in relation to that. So these are all sorts of things that we can just look at and explore, and for some trusts they might want to embody and change some of these things, and for some it may be less, but it's all things just to consider. And then just a word on safeguarding. So in the teacher's terms and conditions document, you're all aware that there is pay protection in place for 36 months. So if you're doing a restructure and somebody's role is changing, to the extent that their pay then changes or is reduced, they still get the benefit of that for a period of 36 months. Now that ultimately means, from an outsider looking in and working with clients who are doing these restructures to really try and make some significant savings, is that you're 3 years behind all the time. Now this is an exceptional level of protection. I can't think of any other sector that gives that level of protection. It's there not because of any legal requirement other than contractual. So again, if you didn't embody the teacher's terms and conditions, or at least this part, into your contracts, then you have more flexibility either to use your discretion as to what would be fair and reasonable, or to put an alternative in, even 12 months or whatever. And we've seen that work. And I know there was a question about, well, how much resistance do you get? From unions and the like in this? Well, of course there would be some resistance, but ultimately you need to make changes to your budgets and need to be able to drive forward change and see the benefits of those. So it's certainly not unreasonable, and I know of a number of academies who successfully implemented alternative schemes, and there's a whole load of benefits to doing that, while still giving you the flexibilities that you need, which again we can talk about in more detail. So just throw that out there as one thing to consider. Okay, conscious of time, I'm just moving on to the next slide, which had just stuck. So when we're talking about changing terms and conditions, I'm not talking about new contracts per se, because there's no changes to make there in terms of the individual. You're offering them a new template. What I'm talking about with new contracts is just putting in place a new template that you're going to work with going forward. In terms of your existing contracts, the legal position is you are bound under those arrangements, and if you wanted to make any changes to those, you've either got to do it within the scope of the actual contract itself, which would be limited, or go through a process to see to get agreement to those changes. Or in substantial cases where there's a real overriding business need, there is another process that can go through, which in the alternative of an agreement, you can go through and force the change and then introduce new terms and conditions, but that is much more risky and needs very careful management. So in the main part, what we're focusing on for today is looking at your new templates for new staff coming forward, but that could also apply to new roles that are created, so including promotions, or if there's a restructure and new roles are being created, even if existing staff are applying for those and then getting those jobs, so long as it's genuinely a new substantive post and not just a variation of their existing role, then you could justify putting new terms in place there. And it's through that means that you start to narrow the gap of the number of people on different terms and conditions. But we'd be able to help with that, as would any other legal provider, in terms of forming a strategy for how you deal with these sort of things. So that leads me on to changing terms and conditions, and I've mentioned a few of these things. I've mentioned that TUPE is harder to change, but it is potentially possible. And the key thing with the TUPE is there needs to be core reasons for what you're trying to do and why, which needs to be built on economical, technical or organisational reason for making those changes, and you need to adhere to a fair process. But also any changes that you make overall shouldn't be any less favourable. So again, that's why I emphasise this isn't about stripping right back and removing the terms and conditions that you've all become so used to and that teachers really expect and you potentially might need for recruitment purposes, but it's all the extra stuff that actually not many people know about on a day-to-day, but really does hit you quite hard with additional costs as and when they arise. In any changes, we've got to be conscious of the duty of trust and confidence with your staff. So that's something that we've been looking at, as well as understanding the extent to which you need to be working with unions about any proposed changes. And on that, if you have collective arrangements in place with unions, I'd very much suggest that you do talk about the new template in terms of consult and get their comments on that. It's a real opportunity to do that now, because your contracts need updating in any event, and whilst unions know that this is a possibility, unions will, to a greater or lesser extent, work with you to get a template that they're happy with, which enables you to move forward in some of the ways that I'm suggesting. But I have seen some circumstances in some areas where unions have been quite resistant and militant. And actually, what they're advocating is to stick with precedent contracts which don't meet the basic legal requirements, not least they don't deal with holiday, for example. So I think you've really got an opportunity now to support why you need to move forward and get those contracts legally compliant, because that actually is to the benefit of their members as well. So work with unions if you've got union arrangements in place. And on that, I just wanted to mention this one case, which is just something to be aware of, given that you're a sector which is highly unionised. This was a case, not an education case, but it was a case which dealt with an organisation that was trying to negotiate pay with unions and getting nowhere. So it went direct to the staff. And the unions brought a claim saying that the employers shouldn't have done that, and by going direct to the staff and not via them to agree a change to the terms and conditions, that was breach of a particular provision which prevents employers doing just that, where the purpose of it is to induce people to move away from unionised arrangements. Now, initially, the courts found in favour of the trade unions and penalised the employers, and it's a set penalty per employee. Now, here they were dealing with a large number of employees, so collectively, that one award, which was about £3,500–4,000 per employee, added up to a significant sum of money. Now, that case went to appeal, and at the Court of Appeal, the decision came out that actually it was overturned for the reason that in those particular circumstances, the company were only going to the staff to agree a temporary change, and it wasn't trying to ultimately induce them to move away from union discussions on a permanent basis. They were quite happy to continue that arrangement with the unions. It was just on this one particular decision about pay at that point. And so that the position as it stands now is it is in the employer's favour. So if you're making temporary changes, it is possible to go direct to staff. But again, we'd always encourage you to bear in mind your employee relations with the unions and to tread very carefully, because this case is going to the Supreme Court next May. We've just heard that's been given a date. So it's really important to understand your relationship with the unions as well, because this could be the make or break as to how you can get arrangements in place that work for everybody. And like I say, that a number of employers have successfully done that in the sector to get templates that don't naturally incorporate all the terms and conditions of the Burgundy Book, Green Book, School Terms and Conditions into their contracts, which give them the flexibility I think that you need and able to enable you to maximise the efficiencies and make management decisions where you can see an earlier impact to those decisions than 3 years hence, and gives you better protection in terms of how you're managing your staff. But at the same time, it still reads very much like an employment contract in relation to a teacher in terms of the expectations that the sector would expect, and that is becoming much more commonplace, but there's still a lot out there where that isn't the case, and it's automatically just incorporates these things without really understanding what that means. So we wanted just to flag those points at this moment, and I'm just looking at some of the questions we've got through, and maybe we can just deal with a few of those. Siobhan, I don't know if you've had a chance to look at any of the questions whilst I've been talking. I've dealt with the one about casual workers and furlough. We had another question about furloughs, obviously something on your mind at the moment in terms of contracts we've dealt with.
There was one query. Sorry, there's one query about entitlement to maternity pay for term time only employees and maternity leave. Now, that is a particularly tricky topic, which won't go into detail at this time because, frankly, it will take us all morning. But you may be looking at, for those individuals, before that person goes on maternity leave, how much of that year they have worked, what pay they have received, and effectively doing a recalculation to ensure that they've been paid for what they have worked up until that point. However, statutory maternity pay is calculated based on the particular salary someone has received at an earlier point in the year before they actually start the leave. So that's based on their actual pay for a particular number of weeks rather than what they should have been paid if they were being paid for what they actually worked. So it is a particularly tricky area, that one.
Okay, thank you. There was one question in relation to the notice that I covered in relation to changing notice provisions. The question was, well, could it be applicable to capability or sickness absence? And I think the simple answer to that is you could draft it as you wish. It could be that you just simply require a 2-month or 3-month notice period, and it expires at the end of that 2 or 3 month period, without the additional provisions that you currently often have, where that's just a minimum and it expires at the end of a particular term So, for example, if you were to terminate somebody now, it's 3 months because we're in the summer term under the standard terms, but you haven't got 3 months to expire before the 31st of August. So you're looking at that 3 months expiring into September, which means that then the actual termination date would be the end of December. And this has become a bit of a problem in terms of settlement agreements as well, and the extent to which you've got some flexibility over ex gratia payments and how they can be taxed, which again would take a bit of time to map through. But what we've done is work up some scenarios where you can, in those situations such as capability or sickness absence, yes, you could terminate just with that minimum notice, and so it would expire, if you're giving 3 months notice now, it would expire at the end of the 3 month period and not a later time, and that ultimately does have cost saving for you. So yes, that is something that you could look at. I mean, in terms of an action list, I think at the very basic, look at your new stuff contracts and think about, well, what do we need to make these fit for purpose to enable us to grow, to respond to change, and to have the flexibility that we need, and the adequate protections in place, and at the very least make them legally compliant with Section 1 updates. And whilst doing that, think about those cases that Siobhan flagged, and maybe a few clauses in relation to that. Think about as well putting in place some arrangements for workers to reflect those arrangements, so that you're compliant and have those Section 1 statements available for those categories of workers. And then one thing that is probably worth doing is just getting your templates looked at, if you're not able to do that in-house, and just with the background of what we've discussed today, think, well, what are the risks, what are the opportunities, and then discuss it at a senior leadership level and with your trustees. And start that process of thinking, well, what could a new template look like? And if you wanted some help on that, we can do a high-level audit of your contracts and just give some recommendations so that you've got a bit more mapping out of how that could work and where we would see the required changes, so the legally compliant bits that you'd need to do against any recommended sort of areas that you might just want to think about. Look at your TTO, turn time only, holiday provisions, and make sure that you're aware of that. And then holiday is a recurring thing. So at the very least, we're advising that you set out holiday in a much better way than it currently is. Quite often I see it's just referred to as detailed in the Burgundy book, and Burgundy book does not set out the level of detail that Section 1 requires, or that I think you need for the level of protection that is now required in the way that holiday entitlement is. So I think that needs looking at in every contract as well. And then use opportunities. So when you're creating new roles with new structures, think, well, does this create an opportunity for us to put new terms in place or not? So hopefully today, I mean, we never set out to give you all of the answers, but what we wanted to do is challenge the status quo a bit and get you thinking as we approach the end of this academic year and move forward. Are you legally compliant? What else do you need to be doing? Are you missing some opportunities? And is this something that you want to think about further? If so, I'd really encourage you to do that. I think we've answered most of the questions, which were a similar theme, but if you did have any questions, please just post them on the chat now and we will endeavour to get back to you, like I say. There is a feedback form that's going to come out and we'd really value your feedback. This is the second type of virtual event we've done with Hayes support, and thank you to Hayes for supporting with those. The feedback from the last one was that it was a really good way of engaging with you. It's very easy for you, and we're quite happy to do more of these over the course of the year, but I'd be very much led by your feedback on that, and particularly interested to hear what kind of topics you'd like us to cover. So the last one was on COVID and returning to work. This one we've kind of taken a more legal and non-COVID related topic, but if there is anything, then please let us know, because we'll take that into account in our planning. So that just leaves me to say thank you to Hayes, and just to remind you to fill in the feedback form. And if you wanted to sign up to our e-briefs, we do lots and lots of postings on all sorts of legal updates affecting the sector, but particularly quite a lot of stuff at the moment, as you'd expect, about coronavirus, so that you can go onto our website and do that. But if you wanted to receive our e-briefs, you can just tick the box on the relevant feedback form. So I'm 4 minutes over, so I'll leave it there, but I just wanted to say thank you very much on behalf of Siobhan and I for attending, and thank you very much. I hope to see you again.